All right, Florida Florida Department of State Division of Corporation, Florida Nonprofit Corporations Act. We'll start reading. We went over the 617-1011. This act may be cited with Florida Nonprofit Corporation. Reservation of power amended with the repeal. The legislative has the power to amend and repeal all parts of any of this act at any time. All domestic foreign corporations subject to this act shall be governed by the amendment or repeal. Filing requirements. All document must satisfy the requirements of this section. Any other section that adds to it or the various requirements entitled filing the Department of State. The act must require the permitting of the filing document of the Department of State. The document must contain information required by the act. It may contain other information as well. The document must be typewritten, printed, or must be legible, and must be legible. Electronically transmitted with the document must be format that may be received or reproduced, written, or printed form. The document must be in the English language without corporate name. It needs not to be in English and written with the English letter and Arabic Roman numerals, and certificate authority required for the foreign corporation need not the English company with the reasonability authenticated by the English translation. The document must be executed by the director of the domestic and foreign corporation or the president and by another in its office. The director officer has not been selected and the corporation have not been formed and incorporated or the corporation in the hands of the receiver, trustee, or other court-appointed fiduciary by the fiduciary. The person executing the document shall sign the state beneath beneath or opposite of his or her signature or his or her name with the capacity in which he or she signed. The document may or may not need to contain the corporate seal, the attention at any attestation of the Secretary of an Assistant Secretary acknowledgement the verification of proof. The Department of State has prescribed a mandatory form from the document under Statute 617-121. The document must be in or on the prescribed form. The document must be delivered in the Department of the filing. The delivery may be made by electronic transmission if the stamp filed by the Department. The document is filled with typewritten, printed, and form but not transmitted electronically. The Department may require that one of the exact formed copy delivered with the document exempt is provided with the Statute 617-1508. The document must be accompanied by the correct law and any other tax exempt penalty required by law. 617-0121 form. The Department of State may prescribe furnish the request of forms, the application of certificate of status, foreign corporation, application for the certificate of authority to conduct affairs in the state, foreign corporations, application for the certificate and withdrawal, the annual report, for which the Department may prescribe the use of the uniform business of the report pursuant to 60606. The Department of State requires the use of these forms shall be mandatory. The Department of State may prescribe the furnish of the request forms for the other documents required with the permit admitted to be filed by this act by their use shall not be mandatory. Fees and filing documents issuing certificates. The Department of State shall collect the following fees, documents, and delivered with the Department of Filing. Articles of the Incorporation 35, Articles of Registered Name 8750, application for renewal, Registered Name 8750, Corporation Statement of the change of the registered agent, registered office, or both, and included with an annual report of $335. Designation acceptance, registered agent $35. Agent statement of resignation from activity, Corporation 8750. Agent statement of the resignation from inactivity, Corporation $35. Article amendment of the Articles of Incorporation 35. Reinstatement article with incorporation with the amendment Article $35. Articles merger with each of the party thereto $35. Articles of dissolution 35. Articles of revocation dissolution 35. Application reinstatement following the administrative dissolution $175. Application certificate authority for the transact business in the state of the foreign corporation 35. Application for the amended certificate authority 35. Application certificate withdrawal by foreign corporation 35. Annual report $61.25. Articles of correction 35. Application certificate of the status $8.75. Corporate certified copy of the document $52.50. Serving the agent substitute service of the process $87.50. Certification conversion limited with the Agricultural Associated Domestic Corporation $35. Any other document required permitted to be filed with the chapter $35. Any citizen support organization that required with the rules of the Department of Environmental Protection to perform with the nonprofit organization under the contract with the Department exact from any of the fees required for the incorporation as the nonprofit organization. Secretary of State may not access any of the fees if the citizen supports organizational certified with the Department of Environmental Protection of the Secretary of State as being under contract with the Department of Environmental Protection. 617-123, effective documentation except for the provided in subsection 2 in statute 617 with 0124. 3. The document except for the filing effective at the time filing on the date of the file with advance for the Department of State, the date and time and endorsement of the original document. The document must specify the latest effective date, and it does not document it shall become with effective with the date and specified unless otherwise permitted with this, as by this act delayed with the effective day for the document may not be later than 90 days after the date of its file. The document is determined with the Department of State and complete with appropriate for the filing. The Department of State may return for the document in the person of the corporation filing it, together being written with explanation of the reason for the refusal to file in accordance with the statute 617-0125. 3. And the application returns the document with correction in accordance with the rules of the Department within 60 days after the mail to the application for the Department. If at the time of the return of the application so request, the writing and final the date of the document will be in the filing date with the would be having applied with the original document that is not deficient except with the person who relied on the record before correction and would adversely affected thereby. Corporate existence may predate the filing date with pursuant to statute 617-0203. 1. 617-121 correcting filed documents. A domestic foreign corporation may correct the document filed with the Department within 30 days after filing. The document contains the incorrect statement. The document was effectively executed, attested, sealed, verified, and acknowledged. The electric transmission of the document was defective. The document was incorrect. The document is corrected by article within correction for the described the document, including the filing date, the specific incorporating document, and the specific incorrect document, the reason for the incorrect, for the manner with which the execution was the defective, the correct, or the incorrect statement, the defective execution, the living executed article, the correction from the Department, the filing article for the correction effective on the effective date of the document, the correct accept. As to the person relying on an uncorrected document where advisedly effective with the correction as those in the articles for the correction effective when filed. 617-125, the following duty for the Department of State, the document is delivered for the Department of State for the following states with the requirement of statute 617-1201 of the Department of State filing of the Department of State file the document stamping it, otherwise endorsing a field together with the Secretary of State, official title, and the date of the time of the receipt after filing the document. The Department of State shall deliver with acknowledgement of the filing with certified copy to the domestic foreign corporation as representative of the Department of State. If they refuse to file with the Department, they shall return to the domestic foreign corporation and represent within 15 days after the document has been received with the filing, together with a brief written explanation for the reason for the refusal of the Department of State duty for the file under these section with the ministerial with the filing refusing the filing of the document does not. After the effective validity and invalidity of the document in the whole and part relating to the correctness and incorrect with the information contained with the document, the created with the presumption of the document is invalid, or valid or invalid with the incorrection with the contained with the document with the corrected with the incorrect. The otherwise provided with the law with this provision with the act, the Department of State shall determine the rule of the appropriate format for the number of the copies, the manner of the execution, method of electronic transmission, amount of the method of the payment of the fees of the document placed under this jurisdiction. 617-126 appeal for the Department of State of the refusal of the file document. The Department of the State refused for the file of the document delivered to the office of filing within 30 days after the return of the document. The document by mail evidence for the postmark with the domestic and foreign corporation may one appeal for the refusal pursuant to statute 120-68 and appeal for the refusal circuit court of the county with the corporation principal office, or if none of the state is in the registered office, it will be located with the appeal of the commencing with the petition of the court to compel the filing of the document by the attaching of the petition of the document of the Department of State explanation of its refusal of the file with the matter of the promptly to be tried to the de novo by the court without truth. The court may be summarily ordered under the Department of State to file the document or take another action, but the court consider with the appropriate for the court. The final decision may be applied with the other civil proceedings. 617-0127, the evidentiary effective of the copy of the filled document, the certified attached copy of the document filed with the Department of State bearing with the signature for the Secretary of State, which may be in facsimile seal of the state is conclusive and evidence for the original document is on file with the Department. Certificate of status. Anyone must apply with the Department of State with the furnished with the certificate of status for the domestic corporation, certificate of authorization with the foreign corporation, the certificate of status authorization set forth in the domestic corporation, corporate name of the foreign corporation, corporate name used in the state. The domestic corporation is duly incorporated under the law of the state and the day of the incorporation. Foreign corporation is authorized to conduct affairs with the state that all fees and penalties owed with the department had been paid off. The payment is reflective of the record of the payment. Department non-payment effective of existent with authorization domestic foreign corporation. The most recent annual report required from Statute 617-1622 have been delivered to the department, and the article of dissolution have not been filed subject to the qualifications stated with the certificate, and certificate of status organs authorization issued by the department may be relied upon as exclusively evident if the domestic and foreign corporation existent with those authorized to conduct affairs in this state. 617-01301. Power of the Department. The Department of the State may propound to any of the corporations subject to the provision of this Act and any of the office director through such interrogatories as may be responsible and necessary property and able to ascertain whether the corporation has complied with the applicable filing with the provision of this Act. Such interrogatories must be answered within 30 days of the filing. Within such additional time fixed with the Department to answer the interrogatories must be full and complete with writing and under the oath. Interrogatories directed by the individual must be answered by him or her, and interrogatories must be directed by the corporation must be answered by the President and Vice President, Secretary, and Assistant Secretary of the Department of the State that is not required to file any documentation to which interrogatories are propounded with the pursuant to subsection 1 relate until the interrogatories are fully answered from full. When interrogatories relevant to evidence of such a document is not in conform with the provision of this Act. C. When the Department determines that the party for such the document have not paid all the fees, taxes, and penalties due the owing the state, the Department of State may be based upon the finding of the hereunder provided in the Statute 213-053-813, bringing action for the Circuit Court to collect any of the penalties, fees, taxes determined to due and owing the state, and not to compelling any filing with qualification registration required by the law in connection with the proceeding of the Department may be within without approval of the court with the full list, and depends any of the property owned by the corporation may further certify the finding of the Department of Legal Affairs and initiate any action permitted by the pursuant Statute 617-0503, which the Department of Legal Affairs may deem inappropriate. The Department of State shall have the power of the authority reasonable and necessary to enable the administrative that have acted efficiently to perform the duties and here is imposed upon it. They adopt the rules of the State Statute 120-536-1, 125-54, the implementation provision of this Act conferring the duties upon it. 617-04-101. As you've in this chapter, definitions. Articles of incorporation includes original amendment of the reinstated articles of incorporation, articles consolidated, the articles of the merger, all amendments thereto, and including the documents designated by law of the state as a charter, but in the case of the foreign corporation documents equivalent to the articles of incorporation for the jurisdiction of the corporation. Board of directors means the group of the persons vested in the management of the affairs of the corporation, or respective of the name of the with small such group is designated, including but not limited to the managers and trustees. By law means for the code of the rules adopted the regulation manual for the affairs of the corporation, or respectively the name of the names of which such rules are domestic corporation, and domestic corporation means the corporation not for profit subject to the provision of the chapter except with the foreign corporation for not for profit means for the corporation not part of the income profit of which is distributed to its member directors, officers, except as otherwise provided under this chapter. Department means the Department of State. Distribution means the payment of the dividend, the part of the income profit of the corporation, member of the director of the officer, and the donation transfer of the corporate as for the income from another non-profit corporation qualified as tax exempt the 501c of the Internal Revenue Code of the government of the organization exempt with the federal, state income tax, and such corporation, governmental organization as member of the corporation makes such the donation transfer the distribution purpose of this chapter. Electronic transmission, many of the means of any form of the communication not directly involving physical transmission for the transfer of paper which graves the record may be retained, retrieved, reviewed with receipt with which may be directly reproduced in the comprehensive legal legible paper for such a recipient through the automated process. Example, electrical transmission include but not limited telegrams, fast mile transmission for the images, text, and sent with Viva electronic mail between computers. Foreign corporation means the corporation not for profit organized under law of the other laws of the state. Insolvent means the inability of the corporation to pay the debts as they become due in the usual course of its affairs. Mail means the United States mail, fast mile transmission provided the mail carriers and handling national mail services. 12. Member meaning of the one having the membership of the right of the corporation in accordance with the provision of the articles in the corporation by law of the provision of the chapter. 13. Mutual benefit corporation means that the domestic corporation is not organized primarily for the exclusion of the religious purposes, is not recognized except under statute 501c3 for the internal revenue of the organized for the public chapter of the purpose of the recognized required upon the dissolution distributed in an act of the United States, state, the local subdivision throughout thereof, the person recognized with exempt in statute 501c3 for the internal revenue of the term does not include the association organized under the chapter 718, chapter 719, chapter 720, and chapter 721 of any corporation membership of the corporation is required pursuant to the document recorded in the county property records. 14. Person includes an individual or any successor entity, means any of the trust receivership or other legal entity that is governed by the laws of the state with the remaining assets allowed to discover the corporation transfer of the existing sole for the purpose of prosecuting defending suits against the dissolved corporation, with enabling the dissolved corporation settle to choose close the business for the dissolved corporation to dispose of the convention, convey of the property of the dissolved corporation to discharge the liability, dissolve the corporation, distribute the dissolved corporation member to any of the remaining assets, but not the purpose for the continuing the business for which the dissolved corporation has been organized. Voting power means the total number of the votes entitled to the cast election with the directive at the time of the determination of the voting power may exceed the vote of the contingency upon happening condition of the event that has not been yet occurred with the member of the class entitled with the vote of the class of the elected director. The determinant of the voting power of the class is based on percent of the number of the director of the class entitled with the elected relatively the total number of the authorized director of the incorporation directors are not elected by members. Voter power shall, unless otherwise provided in the articles incorporation bylaws, by one member to one vote basis. Notice under this act must be written unless the oral notice for the express authorized by the articles incorporation bylaws reasonable under the circumstances. Notice for the communicated by the telephone, whether the oral notice is permitted, telegraph or teletype other than form electrical transmission by mail, while notice of domestic foreign corporation authorized to conduct the affairs of the state and this member of the comprehensive form is effective when mailed and mailed post paid with the corrective address with the mail member's address shown with the corporation current record of the members when accounting the transmitted fast amount of transmission telecommunication correctly directed with the number of the members that consented but received the notice when they actually transmitted electronic mail the correctly directed with electronic mail address of the member that consisted received notice when the posted electronic network with a member that is consented with the consult with upon later such correct posting, the giving the separate notice of the member that in fact with the specific posting, a.e. when the correctly transmitted with the number if the any of the form of electronic transmission consented with the member of the notice that the given correction of the consultant consent by the member that received the notice of electronic transmission should be revocable by the member of the written notice of the corporation. Any of such consent which shall be deemed revoked and the corporation is unable to deliver electronic commission to the two consecutive notices given to the corporation in accordance with his consent. Such an inability becomes known as the secretary of the assistant secretary of the corporation, other authorized person responsible for giving the notice. However, they inadvertently failure to treat such inability to revocation does not invalidate any meeting of the other action. Written notice of the domestic foreign corporation authorized to conduct affairs of the state when they address the registered agent and the registered office of the corporation and the secretary principal office shown as most in the recent annual report. In the case of the corporation has not been delivered an annual report with the domestic corporation articles and incorporating with the foreign corporation application for the certificate of authority as provided in subsection 3 of the elsewhere of the act of written notice if in the comprehensive for the effect of the earliest day of the following when received 5 days after the deposit of the United States and the evidence of the postmark if mailed with the posted incorrectly advised address. C on the date shown with the return receipt if the being registered certified mail return with the receipt request for the receipt signed on the behalf of the addressee. Addresser. Oral notice of the effect of the communicated with the communicated directly with the person notified with a comprehensive manner. Affidavit of the secretary insisting with the secretary transfer agent other authorized agent of corporation with the notice that has been given by form electronic transmission in effect of the absence of fraud primary evidence for the fact stated in the notice and if the act prescribes the notice requirements for particular circumstances, the requirements govern the articles incorporation bylaws prescribe notice requirements not less stringent than requirements of the section other provisions of this act. This requirements govern. 617-02011 Incorporators. One or more persons may act as incorporation of the incorporators of the corporation, deliver articles of incorporation to the Department of State or filing 617-0202 Articles and content of the articles incorporation must set forth the corporate name of the corporation that satisfies the requirements of 617-0401 to address the initial principal office, inadvertently the mailing address of the corporation, purpose for which the corporation is organized, the same with the manner in which the directors are elected and appointed with the lieu thereof. The articles incorporation may provide for the method of election of the directors be stated by law, a provision not inconsistent with the act of any other law, with the limits of the manner of the corporate power or as authorized to act. The street address for the corporation initialed with the registered office and the name of the intent with the registered agent addressed together with a written acceptance of the appointment registered agent as required by 617-0501. The name and address of each of the corporated articles incorporation by set forth the name and the address of the individuals who are serving the initial directors. Any provisions of the non-inconsistent with the law regarding regulation internal affairs of the corporation, including without limitation any of the provision respective relative to the rights, interests of the members among themselves and property of the corporation, the manner of the termination of the membership in the corporation, the rights of upon termination of the membership of the corporation, termination of the remaining member, the transferability, the non-transferability of the membership, distribution of assets, the dissolution, liquidation of the otherwise permitted by law, partial liquidation. If the corporation is to have one or more class members, any classes of members, the provision is designated for the class or classes of members, stating the qualification rights for the members at each class. Name of any of the person designation for the group of the person with who are an initial member of the provision of the effect of the corporation subordinate with the subject of the authority of any head national associated with lodge order of the beneficial association fraternal with the benefits society of the foundation federation other corporation association or organization association non-profit and as any provision under the act with this required by the permitted to set forth by laws any such provision set forth in articles of incorporation need to be set forth by laws. Articles of incorporation need not set forth any of the corporate powers enumerated by this act. 617-0203 Incorporation unless delayed effective the date of the specified with the corporate existence begin with the article of the incorporation filed within the date specified with the articles of incorporation such a date within 5 days by business days prior to the date of filing. The Department of State filing with the articles in the incorporation original record charter of the certified copy of the charter of the corporation which has not been reincorporated under statute 617-0901. It is inclusive of the proof of the incorporated satisfied all conditions precedent to incorporate that the corporation has been incorporated under this act and except for the proceeding of the state of the cancel revoke the incorporation and voluntary dissolving of the revoke of the incorporation or involuntary dissolve of the corporation. 617-0204 liability of the pre-incorporation transaction. All persons purporting act and on the behalf of the corporation actually acknowledge that there is no incorporation under the act. Joint severally liability all liabilities created while the act is exempt from liability to any of the person who have the actual knowledge that there is no corporation. 617-0205 organizational meeting of the directors. After incorporation, initial directors are named and the articles of the incorporation, initial directors shall hold on the organizational meeting with the call of the majority of the director for the complete with the organization for the corporation appointment with the officer adopting the bylaws growing out any of the business brought forward before the meeting. If the initial directors are not named in article for the incorporated, and quarters shall hold the organizational meeting with the call of the majority of the incorporated to elect with the director for the complete with the organization for the corporation to elect with the board of directors who shall complete the organization for the corporation. Action required for the permitted to this act be taken with the incorporated for the directors at the organizational meeting may take without meeting of this action with the evidence by one or more written consent describing the action taken with signed by each for the incorporated director. The director incorporated is calling the organizational meeting shall give it at least 3 days notice for thereof each of the director incorporated so the name stating the time and the place of the meeting. Organizational meeting may be held in or out of the state. 617-0206 bylaw. The initial bylaw of the corporation should be adopted above the board of the director of the power of the alternate amendment of the repeal of the bylaws. Adopted bylaw, new bylaws shall be vested in the board of directors unless otherwise provided by the articles of incorporation or the bylaws. The bylaws may contain with the provision and regulation for the management of the affairs of the corporation not inconsistent with the laws of the articles of incorporation. 617-0207 emergency bylaws. If the articles of incorporation provide otherwise, the board of directors corporation may adopt the bylaws effective only if the emergency defined in subsection 5 of this emergency bylaw may be all provision necessary for the managing of the corporation during the emergency, including pursued for the calling of a meeting before the directors' quorum requirements of the meeting and C. The designing of additional and substitute directors to the board of directors either before or during such emergency may provide from the time to time modify the lines of succession during the stretch of the emergency. All officers, agents of the corporation, and for any of the reasonable incapable of the discharge of the duties and all provision of the regular bylaw consistent with the emergency bylaw that remain effective during the emergency. Emergency bylaws are not effective with the emergency and for the corporate action taken in the good faith of the accordance with the emergency bylaws. A. Bind for the corporation. B. May not be used and impose liability on the corporate director, officers, or employee agent. 5. Emergency exists a purpose of this section quorum of the corporation director cannot readily assemble because of the sum of the catastrophic event. 617-0301. Purpose of the application corporation may organize under the application any form of the purpose of non-pecuniary profit, especially prohibited by the corporation under the law of the state. Such purpose included within limitation charitable, benevolent, elementary, educational, historical, civic, patriotic, political, religious, social, fraternal, literary, cultural, athletic, scientific, agricultural, horticultural, animal husbandry, professional, commercial, industrial, trade, association purpose. The special provisions are made by the law of the organization designated with the class of the corporation. For the nonprofit, such corporation shall be formed under such provision, not under this act. 617-0302. Corporate power of every corporation, nonprofit that originated under this chapter unless otherwise provided by the articles of incorporation by the laws shall have the power to have the succession of the corporate name with the period set by the articles of incorporation, sue with the sue and be sued and appear with the defending in all the actions proceeding within a corporate name to the same extent with the natural person. Adopted as you of the alternate common the corporate seal of the however such seals must be all contained with the word of the corporation of the nonprofit that elect for the point with such officers agent for the affairs of the should require with the law the reasonable compensation. 5. Adopt the name of the man, not adopt change the man with the repeal bylaws not inconsistent with the law of the article incorporation for the ministry of the affair of the corporation exercise of the corporate powers increased by vote with the members cast for the bylaws may direct the number of the directors so the numbers shall not be less than 3 but by any number in excess thereof may make contracts with guarantees and acquire liabilities borrow the money in the state rates interest in the corporation determine the issue for the note for the bonds but more with other obligations secure for the obligations by mortgage pledge and of all any of the property for action on income. Conducting an affair for the carrying out the operation of the exercise the power is granted by this in any of the state territorial district of the possession of the United States of any foreign country. 9. Purchase of the taken the receive the lease for the take of the gift of the devising book bequest and then otherwise acquire own hold improve the other use the other deal with the women and real personal property any interest therein with whether they're situated acquiring enjoying utilizing disposing patents control copyrights trademarks any license other rights and interests thereunder or herein. Settle and convey the mortgage and plead for the lease of the exchange with the transfer otherwise to dispose of all of the other any other property assets. 12. Purchase, take, receive, subscribe, and otherwise acquire and own, hold the vote, and use, employ with the sum, sell, mortgage, lend, pledge, and otherwise dispose of the otherwise deal within share with the other interest of the obligations of other domestic foreign corporations, whether the profit or non-profit, the association, partnership, the individual director, and indirect obligation of the United States, any of the other government, state, territory, governmental district, municipality, with the instrumental thereof, laid money for the corporate purpose, invest with the reinvest for the funds taken, hold in real personal property is secured for the payment of the funds loaned and invested except for the prohibited in statute 617-0833 making the donation of public welfare for the religious, charitable, and scientific education with other similar purpose that have and accessorize all power of the necessary convenient within to and effective with all of the purpose with the corporation and organized merged with the other corporation and other businesses as identified in statute 607-11-081 both of the profit and non-profit domestic foreign if then surviving corporations other surviving the business entity for the corporation for nonprofit or the other business entity for the be organized for the nonprofit entity under the governing statute or other applicable laws permanent with such merger. 617-0303 emergency powers in anticipation for the during an emergency defined in subsection 5 of the board of directors of the corporation may modify the lines of succession and be accommodated with the incapacity of the director for the officers, employee, and agent. Relocate the principal office, designate alternative to the principal office, the regional office, authorized officer to do so during the emergency defined with the subsection 5, unless the emergency law is provided. Otherwise, notice of the meeting of the board of directors needs to be given only with the directors whom it is practicable to reach and may given in any of the practical manner, including the publication of radio. One or more of the officers of the corporation present of the meeting board of directors may be deemed to be the director of the for the meeting in order of the rank, which with the same rank and in order with the second seniority that necessary to achieve the quorum. The director and directors attended with the meeting with any greater number of the effects for the emergency bylaws constituted the quorum corporate action taken in good faith during the emergency under this section and further the ordinary effect for the corporation bind for the corporation and may not be viewed with imposed liability. The corporate director of the officer's employee agent, the officer director of the employee of the acting with accordance with the emergency bylaws is only liability with willful misconduct. The emergency exists for the purpose of the section of the quorum of the corporation. The director cannot readily be assembled because of some catastrophic event to examine the consistent with any of the emergency laws so adopted by law of the corporation shall remain in effect during any emergency upon the termination for the emergency bylaws will cease to be operative. 617-0304 Ultra Virus. Except for the provided in subsection 2 for the validated for the corporation action included but not limited to any of the convenience transfer and encumbrance for the real of the personal property or by the corporation may not be challenged with the ground of the corporation lack of power to act. Corporation power to act may be challenged in proceeding with the member to begin for the corporation to enjoy the act and enjoin the act proceeding within corporation then directly with the derivatively through the receiver and the trustee and other legal representative through the member then representative but still against the incumbent in form of the officer, employee, and then agent of the corporation. Proceeding with the attorney of the general provided with the dissolve of the corporation as in proceed with the attorney general to enjoy the corporation for the transaction authorized business. And member of the proceeding under the paragraph of the 2A for the enjoying the unauthorized corporate act with the score may be enjoined and set aside with the act for the equitability and if all the persons of the party to be proceeding with may be awarded for the loss other anticipated profits suffered with the corporation or any other part because of the enjoying with the authorized act of 617-0401 corporate name. A corporate name must contain with the corporation incorporated with abbreviation corporate INC with the words with abbreviation look like import within language clearly identified with the corporation instead of the natural person incorporated association or partnership with the name with the corporation may not contain the word company or as an abbreviation co. Many containing with the word with the cooperative with the co-op with only with the resulting name, the distinguishing with the name of any of the corporation or agricultural cooperative, marketing associate, the non-profit cooperative association existing with the doing the business and state under the chapter 607, 618, and 619 may not contain the language stating and playing with the corporation is organized for the purpose other than permitted in this act. The articles in corporation may not contain the language stating implying with the corporation connected with the state of the federal government agency for the corporation chartered under the law of the United States and must distinguish the name of all of the entities filing with exempt fiction the name registered on the pursuant to the statute 86509 organized with the registered and reserved under the laws of the state and they are on the file with the division corporate or any corporation eligible to reincorporation of statute 617-0901 may be do so for maintaining the corporation name and the subject to the requirements of the paragraph 1A and 1B. 617-0403 register name application for incorporation may register the corporate name with the corporate name with any of the addition with the requirements of the statute 617-1506 the name of the distinguishing upon the record of the department and state corporate names that are not available under 617-04011E. A foreign corporation will register the corporation in the name of the corporate name with additional requirements of the statute 617-1506 for delivering the Department of the State and filing application setting forth the corporation name as a corporate name with additional requirement of the statute 617-1506 for the state of the county and the date of its incorporation brief, the description of the nature for the purpose of the affair with which it is engaged, accompanied with the certificate existence of the certificate setting forth that such a corporation is a good standing under the law of the state of the country with which is ordered of the document and so more important with the state of the country and corporation for the name of the registered application exclusive of the use upon the effective date of the application shall be effective within life of the close of the calendar year with the application for the registration filed and a foreign corporation registration which is effective the renew of the year by the year or two by annual filing the new application within comply with the requirements of subsection 2 between October and 1st and December 31st of the public preceding year. The renewal application was filed with the renewed the registration of the following calendar year. 5. Foreign corporation registration with which is effective thereafter to qualify the foreign corporation under the registered name with the consent with the written with the use of the name of the corporation, therefore incorporated under the act of another foreign corporation, therefore authorized to conduct the affairs of the state. The registration terminates if the domestic corporation is incorporated with the foreign corporation, qualifies, and incorporated with the foreign corporation qualifies with consent with the qualification of the foreign corporation under the registered name. The Department of State may revoke any registration if and after a hearing is finds that an application thereof with any of the renewal thereof was not made in good faith. 617-0501, registered office of the registered agent, and each for the corporation shall consistently maintaining the state of the registered office may have the same with the principal office of the registered agent who may be either an individual who resides in the state who has business offices identically with such registered office, or A2, a corporation of the nonprofit that authorized for the transact business with the code of affairs in the state with having the business office identical with the registered office. The section does not apply to the corporation required by the law to designate the chief of the financial officer as attorney for the service of the process. The registered agent appointed for the pursuant to the section, successor registered agent appointed pursuant to statute 617-0502 for the process of the being served as shall each for the statement of the following statement with the department and each such for the manner that shall be prescribed with the department accepting with the appointment with the registered agent simultaneous with his or her being designated with such a statement accepting the state with the registered agent and familiar with accepting the obligation of the position for the department of state shall maintain the accurate record of the registered agent and the registered office of the registered agent of the process shall be furnished with the information disclosed thereof by promptly upon the request of the repayment of the required fee. The corporation may maintain an action with the until the corporation complied with the section of the statute 617-1508 with the applicable to pay the Department of State a penalty of $5 for each day has failed to comply up to or $500, whichever is less. 617-0502 to change with the registered office of the registered agent with the resignation of the registered agent. The corporation may change with the registered office of the registered agent upon filing with the Department of State with the statement of the change of the setting for the name of the corporation, the state of the address for the current registered office, the current registered office to be changed with the state address for the new registered office, the name of the current registered agent with the current registered agent to be changed with the name of the new registered agent with the new agent with the written consent, either in the same attached to it and to the appointments. F. The street address for the registered office of the street address business with the office of the registered agent that is changed with identical to such change with the authorized with the resolution daily with the board of the directors, officers, corporation authorized by the board and the directors. Any registered agent with the resign with his or her agent to the appointment with the signing and delivering of the filing of the Department of State the statement to of the registered the resignation mailing of the copy of the statement to the corporation principal office address shown with the most recent annual report and known if none filed with the articles of incorporation others most recently filed document of the statement of the resignation shall say the copy of the statement that has been mailed to the corporation address with the so stated with the agency terminated within the 31st day of the date on which the statement was filed with unless otherwise provided with the statement termination for the agency of the act of the termination register of the office of the registered agent changed with his or her business name of the business address his or her way he or she may change the name of the address and address for the registered office of the name of the corporation which he or she is registered agent by. Notifying all the corporation written with the chain signing either manually or facsimile with delivering the Department of the State filing with the statement of the substantial comply with the requirements of paragraph 1A5 of the setting forth the name of all the corporation represented with the registered agent. Reciting the act that each of the corporation has notified the change with the registered office of the registered agent may be in change with the corporation the annual report filed with the Department of the State. The Department of State shall collect the fee of the pursuant to statute 15092 file authorized in section by Alright, we're going to stop there. Let me check the time on the reel. Alright, we'll go a couple more pages. 617-0503, registered agent deemed the confidential investigation record. Each of the corporation, foreign corporation, alien business organization owns the real property located in the state that owns the mortgage on the real property located in the state that transacts the business and state shall have the continuous maintain the state registered office of the registered agent shall file with the Department of State of the North the registered office of the registered agent with the provided in statute 617-0501, 617-0502. The appointment of the registered agent with the comply with the statute 617-0501, 617-0502 is insufficient purpose of the section with the registered agent appointed filed with the form of the manner prescribed in the Department of State and something the obligation provided within this section each of the company operation each of the such corporation foreign corporation alien business organization fails to have continuous maintained registered office of the registered agent as required with the section liable in the state for up to $500 a year of the part of the year during the corporation foreign corporation alien business organization fails to comply with these requirements the liability for giving them the fall of the upon the compliance with the corporation form with the corporation aligned with the business organization with the requirements of the subsection even the compliance occurred for the action corporation collects with such amount the instituted Department of Legal Affairs may file an action with the circuit of the court for the judicial circuit of the corporation for incorporation alien business organization found with the transaction business in which the real property belonged to the corporation for incorporation alien business organization located between petition for the court and order the direction of the registered agent appointed with the registered office designated and obtained the judgment of the amount of the owned under the subsection in connection with such proceeding pre-department payment may, without prior approval of the court, file the list of pendants against real property owned by the corporation, foreign corporation, alien business organization with the list of the pendants, which shall be set forth a legal description of real property and shall be filled with the public records of the county and all the real properties listed in the list of pendants filed. Any of the other county with the wish for the action is pending with the pendants of the file, but must certify with the copy of the original pendant for the failure of the comply the timely fully and order directing with the registered agent appointed with the registered office designated with the result in the civil penalty not more than $1,000 a day for each of the non-compliance judgment. Any of the order of the payment entered in this subjection to become with the judgment lien against the real property owned by the corporation, foreign corporation, alien business organization, certified copy of the judgment order required as required in statute 5510 with the department may able with itself have the entirety of any of the provisional law of the Florida Rules Civil Procedure. Further, a collection of the obtaining of the bank payment pursuant to the judgment and order of the state through the Attorney General may bid at a judicial sale to enforce the judgment lien of the amount of the people of the judgment lien with the obtained with the pursuant to the subsection. All monies recovered under the subsection shall be treated with the forfeiters under statute 89501, 895 through 85909. Used for the distributed in accordance with the pursuant set forth in 89509. Corporation, foreign corporation, illegal alien business organization failed to have the continuously named the registered office of the registered agent as required with the section 9 may not defend itself against any action instituted with the Department of Legal Affairs by any other agency state until the requirements of the subsection have been met. Each of the corporation, foreign corporation, alien, the business organization owns the real property located in the state that owns the mortgage, the real property located in the state of the transaction business shall pursuant subpoena served of the registered agent of the corporation, foreign corporation, alien business organization, the Department of Legal Affairs, but if the registered agent through the designation representative of the 30 days of the service of subpoena the testimony required by the record showing the filing true copy of the documents, evidence of legal existence, and even including the articles of the incorporation, any of the amendments and articles of incorporation, legal equivalent articles, incorporation of the amendment, the name and address for each of the current officer and director of the entity, pursuant person holding the equivalent position, name and address, and all the prior officer or director of the entity of the person holding the equivalent position for a period not exceeding 5 years previous to the day of the issuance of the subpoena, the name and address for each of the shareholder, equivalent equitable owner of the ultimately equitable owner of the entity, number of which the names is limited to the names of 100 shareholders, equivalent equitable owner of the ultimately equitable owners that in comparison to all the shareholders, equivalent equitable owners of the ultimate equitable owners respectively own the largest number of the shares of the stock of the corporation, foreign corporation, alien business organization, a large percent of the equivalent form of the equitable ownership of the corporation, foreign corporation, alien business organization. The name and the address of all the prior shareholders, equivalent equitable owner for the ultimate equitable owner for the debt with the 12-month period preceding the date of the issue for the subpoena, the number of the names limited to 100 shareholders, equivalent equitable owner for the ultimate equitable owner for the comparison, all other shareholders, equivalent equitable owners, or ultimate equitable owners, respectively, are the only largest number of the share of the corporation, foreign corporation, alien business organization, largest percent of the equivalent for an equitable ownership of the corporation, foreign corporation, alien business organization. If the name and address of the person who is provided with the records of the information registered agent designated with the representative, even required in paragraphs D and E of the do not apply. One financial institution, corporation, foreign corporation of the alien business organization, secretary, which of the registry pursuant to statute 12 of the Secretary Exchange of the 1934 Title 3 of 515 U.S. Standard Code Statute 78 A78 KDK, if the such corporation, foreign corporation, alien business organization filed with the United States Securities and Exchange Commission for the reports required in statute 13 of the Act. 13. A foreign corporation, alien business organization, secretary, which are the regularly traded with the established security of the market, with the located with the United States, the established security market located with the United States, and the so not United States secretary market is designated with the rule adopted with the Department of Legal Affairs. Upon showing that as a corporation formed with a corporation alien business organization with exemption, subparagraph 1, subparagraph 2, subparagraph 3 apply for the corporation formed with a corporation alien business organization, exemption of subparagraph 1, subparagraph 2, subparagraph 3, Treasury does not, however, exempt the organization, foreign corporation, or alien business organization requirements of producing records, information, and testimony otherwise over the under the section within any period of the day, period of the time requires the condition for the exemption did not exist. Time limit of the producing the record of the testimony exceeding the good shown of the corporation, foreign corporation, alien business organization. For a business corporation, foreign corporation, alien business organization designated with an attorney account with the staff of the registered agent, the designated representative shall have the respect of the state agent with the subdivision of the state deemed to have the waiver of the privilege of the otherwise attached to the communication with respect to information required with the procedure pursuant to subsection 2 with the communication among the such corporation, foreign corporation, alien business organization, registered agent, designated representative of such corporation, foreign corporation, alien business organization, beneficial owner of such corporation, foreign corporation, alien business organization, due to comply with the provision of the section not going to excuse the virtue and privilege of the provision of the law of the state of any of the other state or country and with the privilege of provisions authorized the direction of the testimony recorded with required with produced under the subsection 2 with the provided with the confidential shall otherwise be disclosed. 5. If a corporation, foreign corporation, alien business organization shall fail without the lawful excuse to comply with the timely and fully the subpoena issued for the pursuant of subsection 2 with the Department of Legal Affairs may file an action with the circuit court with the judicial circuit with the corporation, foreign corporation, and business organization found with the transaction business from which real property belong with the corporation, foreign corporation, alien business organization located in the order with the compelling with the compliance in the subpoena of the failure with the law of the excuse for the comply with the time with the fully with the order complying with the compliance with the subpoena with the result in the civil penalty not more than $1,000 each for the day with the compliance with the order in connection with the such proceeding the department may without approval of the court with the list of the pendants against the real property owned by the organization, foreign corporation, or alien business organization which lists pendants shall set forth a list of the description of the real property and shall be filed with the public record for the county and the real property located within if in the list of the pendants filed with any of the copy of any of the copy county with which the action is pending. The list of pendants of the file must be certified copy of the original list of pendants, judgment in order for the payment entered with the pursuant to the subject will become adjudicatly with against the real property owned by the corporation of the foreign corporation, alien business. When certified copy of the judgment ordered is required and pursuant to statute 5510, but the department may avail itself and entitled to use a provisional law of the Florida rules, civil the procedure and further collecting with obtaining the payment the pursuant to the judgment and order of the payment. The state through the attorney general may bid in a judicial sale with an enforced judgment lien amount with the amount of the judgment lien obtained with the pursuant of the subsection. All monies recovered under the subsection shall be treated as forfeitures under the section statute 89501 through 89509 used and distributed in accordance with the procedures set forth in 89509. Alright, and we're going to cut the tape at page 20.